And right now we're being joined by former prosecutor and defense attorney David Schwartz. David, thank you for joining us.
Good morning.
First off, Daniel Penny, charged with second-degree manslaughter. So why did the district attorney opt for this charge?
Yeah, I think this charge makes a lot of sense, from a charging standpoint. The DA would have three options. You'd have the basic murder charge, you have manslaughter, and you have criminally negligent homicide. Now, we don't know what the grand jury is going to decide. This is just the initial charge for the arraignment. The DA decided to make the arrest and to charge with the reckless manslaughter, but then it's going to be presented to the grand jury next week, and we'll see what they actually charge out. But the reason why this manslaughter charge was brought forward is because it's based on a recklessness standard. Was there a reckless and unjustifiable risk to human life? And that's going to be the question for the jury.
And one of the questions people will ask is second-degree manslaughter rather than first. What's the difference there?
Well, yeah, so the first-degree manslaughter is an intentional act where a killing, where a homicide occurs. The second degree is based on this recklessness standard. Was there an unjustifiable risk taken in this particular case? Was the chokehold a reckless act where the defendant didn't intend to kill Mr. Neely, but a death did occur by this reckless act? And that's what the jury is going to have to tackle when looking at this.
So David, these charges came without a grand jury indictment. First of all, is this normal, and will they have to be convened at some point?
Yes, it's very normal. Probably 99.9% of the cases are handled this way, where there's an arrest, there's an arraignment charge, and then the defendant is brought. Then the grand jury presentation is made. So this is the actual normal way a case occurs. It would have been the exception if there was a silent indictment, meaning a presentation to the grand jury and then the arrest occurs. So this is the usual way it happens.
And one of the issues in this case was this question of self-defense. Daniel Penny's lawyer says he stepped in to protect himself and others. What is the burden of proof for self-defense under New York law?
Yeah, so basically that's an affirmative defense, self-defense. It's this: was it justifiable? This act, was it justifiable? And under New York law, the affirmative defense has to be disproven by the prosecution beyond a reasonable doubt. So the defense doesn't even have that burden under this. The prosecution would have to disprove that if this case ever went to trial. So bottom line is, was it justifiable? And, we've seen the videos, but the videos don't tell the whole story. You have to look at all the evidence in the case. Now, 6 minutes is very problematic for the defendant in this case. It's extremely problematic that this chokehold was for 6 minutes long, although I think many people could sympathize with the defendant here, protecting himself and protecting the lives of others, possibly. We don't know what all the evidence is going to show.
And David, does that surprise you that we haven't heard from the other witnesses or even the other people that were also holding Mr. Neely down? And will they be charged as well, do you think?
I don't think they'll be charged. I think this is the only charge we're going to see. I think the other witnesses were mere bystanders, and I think a lot of them reasonably thought that Mr. Neely was being restrained after acting erratically. Obviously, this is a tragic event that a death occurred in this particular situation. Didn't seem like there was that intent to kill, which would have made it rise to a murder case. That's why you're seeing a manslaughter. I think the case is well charged at manslaughter, and then there's going to be defenses, and I think there should be no rush to judgment. And for all the politicians to get up and start pontificating about the evidence in the case or what needs to happen, I think that should be left to the courts and the jury.
David Schwartz, thank you very much, former prosecutor and defense attorney.